Hello, my name is Sherrod Seward of Sherrod Sports Visas and Innovative Immigration Law, where traditionally I've spent many years filing PO and EB-1A visas for some of the world's premier athletes, world champions, executives, and entertainers from all over the world. And we've been fortunate enough to have several situations where we learned a lot from filing federal litigation against USCIS and some of the decisions made against the cases, and also had the opportunity to file a lot of FOIA requests with the USCIS as well, to which we didn't really have great results at first. It used to be the case that when you had a situation where a case was denied, you were able to see the adjudicating officer's number, not their name, on the forms of the denial or even on RFEs. As years went along, this started disappearing at the Vermont Service Center and then at the California Service Center, to which you used to be able to file an email on a premium processing case number of the adjudicator, to which years ago they would go ahead and respond with that number, which has a lot of important purposes. You can see that at the end of the day, these decisions are made by people. And some of these people are fair, and some of them might not be as fair of others. So the litigation or the FOIA request allows you to see if you have a pattern of denials by the same person. We've had conversations with attorneys that operate in the same space where we have identified where there are situations where adjudicating officers, the same one, are making the same kind of decisions. So what we decided to do for our own law firm, because we were having issues with USCIS, is file a FOIA request on behalf of the law firm to seek information on all of our cases that had negative results, just so we could see all at once if there were patterns in who was denying those cases. Of course, we were met with a swift denial of all the information from USCIS FOIA department, to which we immediately filed an appeal. The reason we did this is because there are 20 days to which the government can withhold that information before they're eligible to be litigated on that issue. The only way for them to extend that time is to do the denial and ask if you want to appeal. Because if you go to court before appealing, you will not have exhausted all your remedies and the case will likely be dismissed. So one service we're excited about offering is the same thing we did for ourselves, which is we're looking to work with other attorneys, especially in industries such as immigration law or other regulatory based practices where the decision making is driven by the federal government, to do litigation on your behalf. We can take a list of adverse situations that you think might not be unfair, and we can go and see and get the back end information on that, whether it be communication between different officers on that, which we have found, and to see if there are bias between who's been adjudicating your cases against others, to see if that person has a more aggressive route when it comes to adjudicating the cases before them, or to see if there's something specifically wrong with their relationship with either your law firm or your client. Because at the end of the day, these people are individuals, and individuals make mistakes and can have certain feelings. But we, as on the private side, oftentimes do not have the ability to see the names or congruencies in the even adjudication numbers of the people making these decisions. That's why we do FOIA litigation on behalf of ourselves, and we're looking to do FOIA litigation on behalf of our peers. I think it's a great service that we can all learn a lot and keep the government on their toes with transparency, which is good for everybody. We look forward to working with you. If you have any questions or inquiries or like to get started, just do not hesitate to contact us. I appreciate your time.